Welcome. I'm Joanne Law, the Director of Mediation Institute and co-founder of Interact Support. And I'm really happy to have with us Dr. Stan Karosi, who has been doing a lot of work in a number of different areas around the issue of parental alienation, and also Jeannie Magri, who is the founder of Parenting Apart for Parents Who Are Not Together, and similar programs. Dr. Karosi and Jeannie have formed a program that is working on this area of parental alienation, and they're going to share a little bit with us about that, and also some of the broader themes around this issue. Before I proceed any further, I'd like to acknowledge the traditional custodians of Australia and pay respects to elders past, present and emerging. I'm coming to you today from the lands of the Gunai people in East Gippsland, and with that acknowledgement, I'd like to hand over to Jeannie and Stan. If you do have any questions as we're going through, if you could please use the chat to do that. We have tried to organise enough time, but if there are questions, we are aware that this is quite a sensitive and triggering topic. So please, if you are going through the family law system at the moment, please don't share any sort of identifying information. Let's keep the topic general. I've just shared a poll. Hopefully you're able to see that, and if you just give us a little bit of an indication of what your interest in the topic is. Just leave that up for a moment while I hand over to you, Jeannie. And
thank you to everyone, and welcome. Okay, thank you everyone. Thank you, Joanne, and of course welcome to all parents, professionals, and of course Stan and I are grateful that you've made the time today. Today, obviously, is something that's to introduce you to today, but something that we've been both working on for some months from last year, around the concerns around parental alienation and the support that we can give to parents moving forward. And hence, of course, introducing to you today Australia's first parental alienation complex case management services. So of course, first I did thank Joanne. Did I thank you, Joanne, earlier? I think I did. So we'll bypass
Yes, thank you, Joanne.
Yes. So the joint case management rationale was a collaboration between both our services, being Dialogue and Growth and Parenting Together Apart for Parents Not Together. And I think the common feel and theme that both Stan and I have experienced over many discussions is the struggle for many parents when they feel they need to navigate through the process of PA and what that looks like and how the outcome is always dealt with, whether it's moving forward with reconnection with their children or whether they're finding the outcome results with disconnection. So one of the processes for us is to discuss parental alienation. So parental alienation cases are complex to what we consider by definition. It's a narrative process that manifests the patterns of behaviours. It constructs as a new family culture that corrupts the parent-child relationships, normalising, vilifying and stigmatising parents to reject them without any due reason. The complexity result comes from parental alienation behaviours that are common across many alienating settings, but present differently in children within and across the family settings. Family court order assessments vary widely. We're experiencing family therapy and counselling that may entrench alienation, parental alienation as a form of coerced control, family violence not fully understood. We're finding also that opposition to parental alienation from extreme family violence groups and the presumption that rejected parents have contributed to their rejection. So part of the alienating parents that manipulate social and legal processes. So there's a delay in the social legal processes, outbreaks of good behaviour. We find that there's more therapy, there's practitioner shopping, and a common theme in the irresponsible allegations of harm of neglect, including, family violence, sexual allegations as such. In the current times, parental alienation cases do require parents to really project manage, integrate their own disciplines and services. These services can span from family therapies, individual therapy, so parental trauma, parent education, parental alienation in terms of psychosocial education, evidence-based evidence preparation, evidence-based assessments, strategic parent training, coaching for engagement with their family lawyers, and specialist remediation services. So the joint case management process assists parents to take responsibility for expectation and actions. This is now making the current times now history, and hence we introduce to you the Parental Alienation Complex Case Management Services. So let's talk about this collaboration. The collaboration between Dr. Karosi, which is Stan, of course, and myself, and our organisations, more importantly, have become part of the discovery of our personal stories as the founders of both our organisations. Our philosophy has always been to make good of what was once bad as being the most common force. Now, our want is to change using our organisations as vehicles to make this collaboration for the parental alienation complex case management services more sensible, then more sense. The parental complex case management process, let's discuss this pathway. So part of the pathway is quite simple. We would normally, as we've been now working with parents so far, there's either a client referral or we're finding that there's a direct parent inquiry. They contact the PTA office. So what we do here is we offer the consultation 30 minutes for free. That gives us a bit of an understanding whether we are dealing with parental alienation, at what level, and whether it needs to have further discovery through the consultation, the joint intake assessment. Now, if this, of course, is qualified, we then meet, both Stan and I, with the parent, and we start the conversation around their journey. And then this intake will allow us then to brief and to assess whether they will qualify for a proposal for us to then send to the parent if it's deemed high complex as such. The case plan definition referral of both DIG, which is dialogue and growth, and parenting together apart services become more defined with the referral structures that we start to propose who we need for these particular parents in terms of their particular matter. And hence the referral then goes out to our branch of collaborative partners, or those that we believe would be helpful for these parents needing support. The process then runs through a joint case monitoring and coordination. So now what we have is a team of professionals working with us as well as working with the parents. And it allows us then to work into a reassessment process to ensure that where this is working here, is functioning to where it needs to be in that current moment or current time. The reassessment, if you notice here, we take it straight back to here because we work with the parents right up until the end of the matter. And then, of course, this process will continue until such time that the matter is closed. What this does is it allows us to now provide support for our parents. It starts to eliminate a lot of the pressure around what they are expected to know and, of course, who they need to go to. So who are our parents? Obviously, non-residential parents that may have no lawyers, parents that may have only criminal lawyers due to either protection orders, allegations made against them, or they're experiencing offences, previous family lawyers, but they've now reached a point where affordability is now a challenge, especially if they've gone through the full court process or part of, appointed of family lawyers, and those that have got court orders that are clearly no longer working. So these are the people that we are naturally working with or normally would be working with. Our referrals are coming from obviously lawyers, where it's been recognised that PA is a highlight in a particular matter. Our mediators, so family dispute mediators, parents directly are reaching out to us. Domestic violence, obviously services, child protection, officers of the court, education pathway, and other professionals. So we're starting to see a common theme where support is required. So Stan, maybe I'll get you to take from here about our complex case management services map. This gives you a bit of an idea of what it is that we're actually working with many of our parents, depending on what their requirement or what their need is in the moment.
Yeah, thanks, Jeannie. That was a great introduction to that whole concept of integrated services. Just quickly, I've been working directly in the field of parental alienation for more than a decade now. And my observation and experience has been that where cases fall apart or where a situation falls apart that's beyond remediation, it's usually because they're not prepared in a way that the evidence is accepted. Sometimes parents don't receive the best legal advice about the pathways open to them. They end up with court orders that are either unenforceable or useless, often within 24 hours of consenting to them. And also, historically, there have been inadequate remediation options available. So if our systems, our social institutions don't know what to do, they won't recommend anything. And so their responses to a situation involving alienation are constrained by what they know they can do about it or not do about it. And so the other angle that I've come across in working with alienation cases is that the best strategy that a harmful and abusive parent can take is to do absolutely nothing. Passivity is their best choice. And that means that as an alienated parent, as a parent subjected to this particular form of coercive, controlling family violence, you're the one who's got to take action. And every action you take always involves some criticism. It always involves a claim that you're actually perpetuating the situation you're actually trying to resolve for your children. So what we've learned over the years is that all of these cases require very different disciplines, different approaches that have to be integrated and work together. So we know, for example, that being alienated from a child is a unique form of trauma. Very few social science practitioners actually understand. So an alienated parent comes to us automatically traumatized, often in ways they don't fully understand. So we found that the best way to go forward with them is to teach them and help them learn what happened. How were they abused? How were their children abused? How was power corrupted? And if necessary, we'll refer them to very specific psychotherapeutic services to deal with that. Because the idea is you have to be the parent of choice. You have to present a case where your children need you in their lives, whether they want you or not. And in my experience, mothers who have been alienated from their children are disproportionately traumatized compared to men, and often unable to bring their cases forward into family law. And that's why we need this very specific support. We've also found that over the years, the models of evidence, what actually is the nature of parental alienation as a set of narratives in families that stigmatize a parent, marginalize them in the family, exclude them unfairly without due cause, requires a very specific form of evidence gathering and curating of that evidence to show that what happened to that child is actually harmful and abusive and has to be remediated. So you actually have to make your case, whether you go through family law or not, that there's been harm to your child and that the words spoken and the way they are spoken are the tools, the weapons used against them. So when a child is recruited into making, for example, false allegations against a parent, or where a child is contemptuous towards a parent and the other parent, their residential parent, does nothing about them, that's a piece of evidence that shows that the parent actually supports the contempt. They're actually supporting undermining the child's relationship with an alienated parent. And so the next step after that is the court. If you go through family court, the court will often order or assign a family consultant or some other professional to assess the case. Basically, the judges are going to say, I've heard both of your stories. They're both polar opposites of each other. I want someone independent to advise me what's in the child's best interest. And what we found is that the parents who are coached through the process of preparing evidence, of how to present themselves and their evidence to court-appointed practitioners, generally do better than those who don't. Okay, so we do have lots of family consultants and professionals in the family law system who either don't know anything about alienation, know the wrong thing about it, or are opposed to the idea. So if we present the evidence to them the right way, we will know from their responses whether they even read your affidavit, for example, or what assessment models they use. So we'll know how to deal with the outcome. And if you present yourself the right way, you're more likely to get a better outcome than if you don't. So there's two main types of reports that parents seem to be ordered to get. One is a child inclusive assessment, which is a very brief form of assessment about what's going on for the child and what are the likely directions that should be taken. And the other one is a full family assessment, which may take a couple of days in some cases, where a family consultant will interview both parents individually, maybe together, interview the parents with the children, if possible, and speak to the children alone, and then produce an assessment with recommendations to the court. Okay, so how you conduct yourself, how your evidence is prepared, is influential on the outcome of that assessment. So again, we also work with family lawyers. We can consult directly with family lawyers. In other words, they can retain us to advise them about a case. The beauty of that approach is that we don't appear as witnesses. We're not visible to any other party because we are retained by the lawyers solely for their guidance. Or we can be retained by a client through their lawyer to present remediation options to the court. In some cases, in severe cases, a reversal of care and responsibility is the only viable way forward. And we've done several of those cases in Australia, and we use a very specific evidence-based remediation to do that. We also work with other family professionals, such as reportable family therapists. So one of the things that very often happens, in fact, it happens nearly all the time, is that there'll be an expert report and the report will nearly always recommend reportable family therapy. Now, the evidence is in on this one that if reportable family therapy works in an alienation case, it is by definition mild or moderate. If it doesn't work, your case is severe and the therapy will make it worse. So at that point, that's where it should stop. But all too often, there's another recommendation for even more therapy. So that's how one of the ways we know that we're working with consultants and practitioners who may not fully understand the presentation. And family lawyers need to know that. So when you're working with your legal counsel, they need to know that there's one shot at family therapy in an alienation case. If that doesn't work, game over. The other thing too is many parents, targeted parents, for a variety of reasons, self-represent through the family law system. And that's a very difficult pathway to go down. We'll do our very best to help you, but you do risk being outmaneuvered. But there are a growing legion of self-represented parents who've had some modicum of success that we can possibly refer you to. Also, there are other ways of remediating alienated parent-child relationships that don't involve family law. So for some people, they've been through family law, it hasn't worked, they haven't got the resources or the desire to go through it again, or they have another reason why it's not where they want to go. And so there are very specific forms of remediation that we can direct you to that use what we call counter-alienation narratives to attempt to undo the alienation process with children. It's more difficult in some respects and easier in other respects than taking a legal approach. The problem with a legal approach is that it's inherently conflictual. It inherently requires polarization of two views. Each view is radically different about what's in the child's best interest. And what we have found is that children's contact services, their reports are admissible as evidence. And so how you conduct yourself during supervised contact, or even if it's unsupervised, can actually affect your case. And so one of the things we do, for example, is parents having supervised contact with children, we'll coach them into it before the contact and debrief them afterwards and help them set up the next contact. And they're more likely to get reports from contact supervisors that support their claims. All of these different angles have to be project managed. And it's not the job of a lawyer to do it. And it's too big a task sometimes for a parent who's self-representing to do it, or too big a task for a parent who's not going through family law to do it. Because each one requires a different professional discipline to address. And that's where the integrated case management comes in. And that's why we're doing it. How is that, Jeannie? Did that address? We've got quite a few questions now, I think. How do we want to deal with the questions in the chat?
And on mute, Jeannie. Yeah, is it time? I think there was one earlier on that asked about what kind of parental alienation family court assessment can I seek if I believe the other party's taking deliberate action. So I think you've spoken to that a little bit.
Yeah.
But there's a later question about the challenge of finding a report writer who I think they may have had contact trying to find someone in Melbourne suitable.
It's very difficult for us to recommend specific family consultants. And we've been caught out a couple of times with consultants who we thought we knew what they were doing based on previous reports. They get involved in a case that, stands out to us as a case involving alienation as a form of family violence, and they miss it. And so there's a general problem with the professional education of professionals inside family law about treating alienation as a form of family violence. And the challenge that they face is that in many cases, the ones that are highly contested in family law involve cross claims of two different types of family violence. So a targeted alienated parent will claim the children are being alienated against me. That's a form of family violence. And the other parent, the residential parent, will say the children are a victim of family violence from the other parent. And so these competing claims have to be resolved by a family consultant. It's a monumentally difficult task, and they need better professional education than what they're getting now. That's as much as I can say in a general response to that question.
Just to extend on that too, Stan, I think this is why a service like this has been long overdue, because our focus is then to take the parent and then to prepare them, to set a tone, what they need to expect through that process, and how to actually present themselves so that they're not highlighting the idea that the children have been removed from them by another parent, but more about the behaviours and that impact on the children by the other parent and what that then means. And so these are the intricate details that we are able to expand on in our process to give parents an opportunity to be prepared and to understand what they need to do, because that's the part that they can really manage well.
I might just lead on from that, Jeannie, if I may, and address two questions in the chat.
Yeah.
One of them is about what do you do if there's a battle over consenting to which family consultant the parties are going to agree to, okay? And by definition, an alienating parent's never going to agree to a family consultant that they think is going to reveal what they're doing. And by definition, a targeted alienated parent's never going to agree to a family consultant that doesn't know what they're doing, right? So what can happen is that you chew up a lot of legal bandwidth and money arguing over this point. One of the ways to break that cycle is to say, it actually doesn't matter. Just get one. Get the report. Let's say the report is a dud for whatever reason. They missed the evidence. We're going to know that because, remember, you've curated your evidence according to evidence-based models. So we will know from that model whether they even read the evidence and if they understood it. If that's the case, one of the services that we have is what's called a shadow family consultant. So your lawyer in particular can actually engage that family consultant to provide an additional family report based on the reports only to the family court that might be a dissenting opinion or a challenge to the prevailing view that goes against you. The other thing that your legal counsel can do, and it's a lot more difficult, I think, for a self-represent litigant to do this, is to engage our family consultant directly as their advisor. So they can then advise legal counsel about what are the points of weakness in a particular family report and how to cross-examine that witness in court. And so just because a family consultant has done a report that doesn't pick up the right evidence that you provided doesn't mean they get off scot-free. The judge is at liberty to throw that report out, particularly if they're cross-examined really well. So that's one way of dealing with it. So that's on the issue of fighting over consent to a family consultant. The more time you spend fighting over that one, the more alienated your child becomes because matters are not progressing.
So Stan, if just while we're talking about family reports, you talked about coaching people to prepare, and sometimes people hear that and they think, oh, you're teaching them to say the right things that will make their report.
Yeah.
But what's your response to that?
Okay. What we find, and what I say to parents, is that for an alienated parent, the best evidence you ever have is you. it's your authenticity and your genuineness, okay? Because a family consultant, a lawyer, a judge, me, Jeannie, anyone you meet, is likely to be presented with two different versions of reality, and it's very difficult to determine objectively which one makes more sense than the other. So often the only thing we have is authenticity and genuineness. And so we can't teach you the right thing to say because there isn't a right thing to say. There's only what's in your evidence, actually, and that's an evidence-based process. So we never tell parents, don't say this or don't say that, or make sure you say this. We point them to the parts of their evidence that stand out, okay? And remember that you don't, as a parent, you don't have to preach to family consultants about, oh, this is in my affidavit, because they're supposed to have read it, right? Okay. What they're really sussing out is what sort of parent are you and whether the child has a reason to reject you. And that is actually about how you present. And that's principally how we coach parents. The one thing we do tell them to be very careful of is to lecture family consultants about parental alienation, okay? Remember, and what we say to them is that you're actually on trial as a parent, whether you like it or not. So your mission is not to become overly defensive, but to present yourself as the genuine article.
Yeah.
And that's what a family consultant has to do, choose the genuine article from the fake one.
Yeah, and I'm certainly aware sometimes parents get confused and think it's a counselling session or something like that. And
yeah,
definitely not.
We disabuse them of that one right away. No, it's not. Yeah, as I said, you are effectively on trial as a parent, particularly your version of what you think is in the child's best interest is under question. Okay, I might use an example here, Joanne, if I may, okay? By the time a case involving alienation is heading towards trial, it's becoming fairly obvious that it's really not possible to share parenting, okay? And even attempting to do so is probably going to be harmful to the child. Shared parenting is really an aspirational goal that works really well for kids when parents can actually collaborate together on sharing their love with their children without judgment of the other parent. Okay, it almost requires a better relationship post-separation than the parents ever had while they were together in some cases. So what family consultants will sometimes check out is effectively your parent's grasp of reality. Whether if you're making a claim of alienation against the other parent, do you think it's possible to share parenting with that parent? By definition, the answer is no, usually, okay? How you respond to that question, you need to be less blunt than what I have been and be more expansive in your reasons why you might think that as much as you may want to share parenting, historically, it's simply not been possible and it's been harmful to the children to try and do that. In some cases, it may be possible, but you have to be able to explain your reasoning. And that's what a family consultant is very interested in. How do you see the situation? And if you're unrealistic about it, they may probably take the view that you could be unrealistic in other areas as well. Okay, so there's an example of how we would coach you based on what your evidence says. Because sometimes it's not possible to share parenting, and sometimes it is. It's not universal. But how you respond to the question is very revealing to the family consultant about how you see the reality for your child, whether your child's best interest is at the center of your focus or whether your needs for the child in your life are the center of focus. That's a very key assessment point for family consultants.
Look, as you know, I'm a family dispute resolution practitioner, and our goal is to try and help people to sort things out and stay out of court. And the parental alienation, sometimes it feels a bit like a slippery slope that we see signs early on that we're concerned about, that things may get a lot worse. Any Do you have any support or ideas around that early stages?
Yeah, I do. And there's another question there about counter alienation strategies I'll come back to. On the mediation front, my view of mediation is the earlier we can deal with a case involving claims of alienation, the better. If we can triage them out of family law altogether and come to some collaborative agreement, that's fantastic, okay? It also means, by definition, we keep these cases at a mild level. So one of the things about mediation in an alienation setting, and with due respect to family dispute resolution practitioners, many targeted parents report them to us as though they are hostage negotiations, okay? So they have this feel for them like, how come I'm negotiating for my child spending time with me on the presumption I've done something wrong when that's never been established? This should never have been allowed to happen in the first place. So why are we now negotiating on terms that presume there's been something done against the child by me? And so it places mediators in an awkward position about whether they are mediating in a sense where the parties are there in goodwill, okay? Because if alienation is involved, one parent is a hostage taker, to put it bluntly. And is it appropriate to mediate in that setting? And the answer is typically not, okay? Unless you can exploit some wiggle room there in getting the child to spend some time with the other parent, it isn't going to happen. The other angle here is that in amongst all of this, there is a voice of the child that gets lost, okay? And even alienated children have something to say. And when they say something about their desires, their attitudes towards the other parent, that is revealing of whether they're alienated or not. If they are alienated when they say things, it's unlikely that mediation is going to work at that point. Having said that, there are many exit ramps in going in the family law setting where mediation has a role to play. And I think that there's a broader sort of role for mediation, not just in trying to come to an agreement, but in trying to set the parameters in which an agreement can happen, okay, to prepare the parents for making those agreements. Because what tends to happen as things escalate in law is that usually the upside doesn't get any better, but the downside gets worse, okay? And both parents can stand to lose a lot more than they think if they go to trial. Does that help, Joanne?
It does, yeah. It's certainly a challenge because, as you say, as mediators, our role is not to judge, and we
have the
status quo at the time that it's the people come to us. One of the things that you talked about was that for an alienating parent, doing nothing is a strategy. So the stonewalling, the delay tactics, which we're all familiar with. So the changes to the family court, where they're in most cases ordering people back out to mediation, do you think that's got the potential to improve the situation where they're faced with, if I don't give something here, it's going to be a long and expensive process?
It's a sword that cuts both ways.
Yeah.
I'm going to refer to an international model used in another country where mediation is used in a triaging role right up front, okay? And in the triaging role is either this case is amenable to a mediated agreement or it's not, okay? And if it's not, alienation would be a major reason why it's not, because you've got one parent who's not negotiating with goodwill, who is resisting coming to an agreement, or the agreement is set up in a manner that's flagrantly violating a child's rights to a relationship with both parents. And the mediator is just going to say, yeah, that's sorry, out of scope, right? And that's where it ends up coming under what's called therapeutic jurisprudence, which is a complicated way of saying an iron fist and a velvet glove. And so the velvet glove, the ongoing social science, therapeutic, remediation, assessment services provided under a legal umbrella. So from that point on, a judge is watching the case all the way through. So there are off-ramps in that process. For example, when it becomes apparent to an alienating parent that their case isn't quite as solid as they thought, and they stand to lose that which they most are trying to preserve, that's often a signal that some negotiation is possible. Okay? And so that's where there's a potential role for a mediator in that system. So cases are not destined automatically to go to a final trial. There are opportunities along the way where the price of continuing for both parents becomes very high indeed. Okay. One of the missions or strategies for alienated parents, if they're going into family law, is to allow the alienating parent to undermine their own case. And at some point, their lawyer will say, that case is not as strong as you might think. Do you want to mediate? You want to offer a deal? Is there a prospect of some consent process here? So in that case, there's a role for mediation. In that situation, it's more likely that the terms are tilting in the targeted alienated parent's favour. So there are various ways that mediation can enter into the fray, provided there's an overall model of iron fist and velvet glove, which we don't have in Australia, but they have in another international jurisdiction, and does work quite well. Because once a judge is looking, they keep looking until the case is closed. They don't in Australia, they let the case go. So that's a qualified answer, Joanne. It's possible, but we need more work.
Yeah, absolutely. Another import that we've got in Australia now is parenting coordination. So after an order is in place, if there is an order that does have contact, rather, yeah, trying to help make that work. Any thoughts about that?
Parenting coordination is it's still relatively new in Australia. It has a role to play in some international jurisdictions. A prototype model we used to have in Australia, I don't know if we still have it, used to be called parenting orders programs. And they were designed to help parents understand what their obligations were to the orders they got and what was getting in the way of them complying with those orders. Okay. So parenting coordination places a lot of power into a professional appointed by the court to coordinate what the orders require of both parents in relation to their child. So they're actually advocates for the child, basically saying, well, the orders say this. How are you going to do it? What's getting in the way? Okay. And they do have the power to make recommendations back to the court. I think there's a gap that they're filling that has a role to play. My concern with all of things like parenting coordinators is that when a case of alienation is established up front, it must be dealt with fast, within a matter of a month, 2 months, 3 months at the most. The longer alienation cases remain in a legalised setting or otherwise unresolved, the more they consolidate. And alienating parents are very imaginative in the ways they undermine all the therapies that courts order. So we've seen countless times how an alienating parent will effectively gaslight a reportable family therapist and make the therapy useless. They can do that with a parenting coordinator as well. The good ones will spot it straight away, but it's just wasted time again and wasted money in being once again told something that was obvious from earlier assessments. And that's where the therapeutic jurisprudence model has some merit in to introduce that into Australia. So you get the iron fist and the velvet glove happening fast. Speed is of the essence in these cases.
No, that's excellent. And a few times you've mentioned the importance of professionals working in this area being educated about parental alienation, but also supported. One of the questions in the chat is, do you offer supervision for clinicians working in this space? So is that part of your models and support for?
We have done that in the past. I've been approached by clinicians over time looking for supervision, particularly around specific cases. And we will take that on an individual basis if someone wants to have that professional support. And I've done that quite recently with a professional. What we have to be very careful of is that we're not providing professional supervision to a professional who's working in a case in which we are also involved. So that's actually a conflict of interest we have to be very careful of, okay? It can be done. We just have to maintain anonymity of the clients that you're working with. It is possible. So the short answer to that question is yes, we can do it.
Okay, and I think we'll share out your contacts again later. Now, I think there are a couple of questions a little bit more around that iron fist in the velvet glove, the therapeutic jurisprudence. Could you maybe just clarify that a little bit more?
Okay, so it's a complicated term that lawyers would understand. I'm so sorry I used the legal jargon here. So therapeutic jurisprudence refers to a model of therapy delivered under the law. In a perhaps a crude example might be mandated treatment programs for people who have serious mental health issues, okay, who are so ill they're unable to make decisions that are in their best interests. They're so ill they need medication, but they won't take it unless they're compelled to do so. It's a very tricky area that involves, on the one hand, a legalized approach to treating someone who's very unwell, but on the other hand, potentially involves legal coercion. So it's a complicated area, okay? Therapeutic jurisprudence in the context of family law basically presents parents with this option. You've got a choice. You can engage with this professional we're going to order, or your case progresses to trial, because that's where and the judge will make a decision and you will be disempowered in any decision making because somebody else is going to decide for you, okay? And what generally happens in a therapeutic jurisprudence model is that the parent who does not cooperate or undermines the process generally undermines their genuineness and authenticity to the extent that when the judge is involved, they take such an adverse view of that parent that they won't consider any evidence at all from them as being credible.
Mm.
And there are also sanctions within a therapeutic jurisprudence model for parents who don't cooperate or who undermine the process. And so if a family therapist who's reportable reports back to the court and says, this process would have worked were it not for one parent who undermined it, and there's no further basis for family therapy in that context, that's a very strong signal to a judge to say, you know what, you've had the therapy, now comes the law. So in the country where this is done, the family law system is more inclined to take a strong action, and their legal system allows them to do that. And I think in some cases, parents they do spend time in jail if they don't cooperate with the orders.
Mm.
Now, we don't do that here. And the biggest problem we have in our family law system is orders simply aren't enforced. If a parent doesn't want to follow the orders, they don't have to. And then the targeted parent then has to take enforcement action or contravention action, which is frightfully expensive and completely unpredictable.
Mm.
So that's something that changes in a therapeutic jurisprudence model that says we're taking the side of the child. It's in the children's best interests that the parents sort this out now. And to help the parents sort it out now, we're giving them all these services that they need to engage with now. And if they don't, we're going to deal with it now.
Yeah.
Okay. Yeah.
Someone's re-raised that question about counter alienation measures. Yeah. But perhaps just before we move off from the court, ultimately that judges have the power to order that the children are changed, their residence is changed to that of to live with the alienating parent, the alienated parent. However, it's pretty controversial because you've got kids that don't want that. Because they're
okay, I can respond to that. We've done several of those cases in Australia, and the methodology we use is evidence-based. So we've got children who have made repeated allegations of family violence and sexual abuse against the parent they reject. The family court has found that there's no basis to those claims, either from the children or from the residential parent. Very often, there has not been any police investigation of such claims, and where there is, no evidence has been found that warrants any concern. But the children, the care is reversed on the basis that there's no reason for the children to reject the parent, and they're repeating those views is harmful to the child because they believe something about the parent that they have been induced or coerced into believing that as though they thought of it themselves. So we get children to us who believe that they're being put in the care of their sexual abuser. Within 24 hours, they're off having dinner with that parent, and they have questions in their mind about whether they thought of it or whether somebody thought of it for them. And the reason why the process works is because the evidence is in that secretly children who have been alienated, that is coerced into a false view of a parent they once loved, secretly want that parent in their lives, but they can't say so. It's monumentally unsafe for a child to tell a family consultant, "No, it never happened. Mum or dad told me to say that." It's because these reports are available to everyone, including both parents. So the parent who coerced them into saying that is going to know they said that. So they can't tell anyone. And this is almost a fatal flaw in our legal system. So these children basically are looking for a get out of jail card. And the judge is handing it to them by saying, you know what? I've taken into account what everyone said. I've listened to what you've had to say, at least through your family consultant. And I'm making a decision that's in your best interests. And I want you to have a relationship with both parents, but firstly with the parent you've rejected, because that rejection has no basis. It's not proportionate to your historical relationship with that parent, and there's no evidence to support the claim that they were abusive to you. That's it. I've made my decision. The adults have spoken. That's what a judge does. Okay. The children stage a brief protest, a little bit of anxiety, a bit like going to the dentist, and then it's done. And it's a simple process. It doesn't traumatize them, doesn't harm them, and they're over it, the initial shock, very quickly indeed. And they come out of that reversal of care process and the methodology loving both parents, wanting a relationship with both parents. Okay. At firstly, enjoying the relationship with the parent they once rejected.
Excellent. We've got a question about whether the cases are reported, and if so, the citation. So maybe we can gather that later. And
yeah, there is one precedent that's been published under a pseudonym. Now, I can provide that.
Yeah, perfect. We'll share that out because they're always interesting to read those
Sure.
sort of things. But it actually, some of what you shared there segued into those counter alienation measures. So if children do actually, if it was safe to do, want to have that connection with the other parent, what are some of the strategies perhaps that parents could?
Okay. I'll try to use two examples. The first example I'll use is for parents who are not going through family law. So what they're faced with is a child who is hostile to them, either refusing to have any time with them at all, or when they do spend time, they're contemptuous, rejecting, they're seeking to harm or hurt the parent they're with. And often the forms of contact the rejected parent has are quite limited. If you're lucky, if you have a mobile phone number, a social media contact, there's certainly no guarantee that if you try to talk to your child through their residential parent, your message will get through at all, let alone the way you said it or intended it. So the framework that we use is to never respond to the content of what your child says, but always respond to the underlying process and the sentiment that is expressed. And when I say the sentiment, and sentiment's another word for mood or feeling or emotion, and I use the word sentiment to be more nuanced about it and non-therapeutic. So I come back to that piece of evidence I referred to, where children secretly want a relationship with a rejected parent, but it's unsafe for them to say it. And the only way they can reconcile that terrible internal conflict is to reject the parent they can reject, because they secretly know that parent will always be there for them. They do not have that sense with their residential parent, because their relationship with them is always conditional on them accepting that parent's view of reality without question. Okay, so what we coach rejected parents to do is not to respond to the harsh rejection on the content, but to respond to it by going underneath it, to say, wow, that must have hurt you terribly to say that to me, given our past history together. Do you remember that time when I bought you that article of clothing or toy or whatever, or I rescued you from the sinking kayak or something? So you always tie those strategies to memories of the past where a child has enjoyed a loving relationship with you. That model, to be blunt, is designed to keep your child uncomfortable. Your job is not to make their life, it's not to validate what they're doing. It's not to make them comfortable or to implicitly give permission for them to reject you. It's to bring into their attention the fact that they once had a loving relationship with you, and that what they're now doing bears no connection with that history. Okay. And so there's Winston Churchill had a saying that if you're going through hard times, keep going. Your child is going through hard times. Okay. You can't turn them away from that. It's too late for that. You didn't cause it. They have to keep going. And so do you. So you keep them in this uncomfortable space where the internal conflict is apparent to them. Will they resolve it? That's up to them. It won't resolve if they're not aware of it. And that's the broad framework. And your basic mission is to always be empathic. You always acknowledge the feeling that's there, and you always move the feeling into another space. Okay? But you never validate the alienating behavior towards you. Okay? The only time you challenge the content is when an alienated child hits you with flagrantly incorrect factual information, and you can produce some independent document that says that never happened. A classic might be, you're useless as a parent, you don't even pay child support. All right?
Yeah.
And you've got the documentation from Services Australia that says you're paying through the nose. So you have independent facts that say you are in fact doing something that child has been told you are not. That's the only time that you address the actual content. So that's a very broad framework. Okay, all right. Inside family law, when we're doing the workshop, we don't do that. And the reason why we don't do that is that once reversal of care and responsibility is decided as the best option for the child, that's the end of therapy. By that time, therapy isn't going to work. And what we do is we teach children it's like a school environment. That's the model. Everything that happens in the methodology is just like going to school. We're just school teachers. So we engage them with learning materials that show how easy it is for adults to manipulate people's opinions. And it's just like a school. They apply that to their own situation without any facilitation from us. One example in a case we did a couple of years ago was, again, a teenager, 14, absolutely convinced that their targeted parent had sexually abused them. The court had found that had no such thing had ever happened. We had some education materials about how easy it is to make false allegations seem like the truth when in fact they're not. And on watching that, this young adult said, "Oh no, that never happened to me." So immediately recanted. By itself, that doesn't necessarily mean very much. Okay. So our response was, okay, so if that's the case, what stopped you from spending time with that parent? The response was, "Oh, I was too busy at school." Now, by any stretch of imagination, that is a monumentally unreasonable sort of case. So then we asked them, so do you know any of your friends at school who are too busy to spend time with one of their parents? We took it back to a school model. At that point, there was silence and we moved on. And that was a shift in that child's relationship with their targeted parent, okay? Because there was a compelling illogic to that particular case, okay? What the example I've given you is actually called critical thinking. It used to be called clear thinking in English when I went to school. I don't know if they still teach that. I think they should, okay? So we very gently use their own information to get them to question how they came to that view. And the view they came to was startlingly irrational to them once they said it. They just needed to say it, okay? So that's an example of how it works on the family law side. It's not therapeutic because we're way past the therapy at that point, okay? And by that time, that particular young adult had seen other materials that generally showed how easy it was to misinterpret information. Some of you may know of Stanley Milgram's experiment in the 1950s, where he convinced people to deliver electric shocks to other people they couldn't see, how authority works, how we can assume authority knows what's right, what's the difference between a just authority and unjust authority. So we teach children how to discern the difference. They then apply it to their own situation all by themselves.
No, that's great. So that's really helpful, actually. Thank you. I made some notes. What about the situations where there's no contact? So parents often really struggle. What do I do? What can I do?
So the no contact situation is incredibly difficult for rejected parents. And it's been made even more difficult since the 2012 changes to family law that introduced the family violence angle. Look, what we get parents to do, what we tell them is that even if your child doesn't answer their mobile phone or doesn't respond to your text messages, they know you're calling them. They know it's your message. Okay. And so everything you send to them lands like a bomb. Okay. It has an impact. And so it's not so much what you say, it's the fact that you tried. And so often we tell parents to start out with the smiley face, thinking of you. I saw this toy in the shop and I remembered buying you your first fishing rod. You always have a memory. Never ask for anything, never make any implied emotional demand, nothing. And so you're always sending the message that I'm here, the door's open. Now, the problem with no contact, where it occurs when the child is completely isolated. There's no phone contact, no email, no social media, you don't know where they are, and you've got an alienating parent who's willfully not following the law in any sense. So at that point, if you choose not to enter family law, you almost run out of options. The problem you've got is the more you reach out to your child, the more likely you are to trigger the family violence provisions of state laws, which are much harsher. The threshold for an intervention order is very low, easy to get them, very difficult to get rid of them. And one slip and you can be on the receiving end of an intervention order that might bar you for 5 years or something for your child, from your child. At that point, your only option is family law. You haven't got any other options other than letting go in the hope that your child will seek you out. There's no real evidence to support the fact that they do. It does happen, but we don't have a clear understanding of what are the parameters that make them do that. What we do know is that from alienated children who have reconnected with an adult later in life, that parent created a sense in the child that they would always be there for them by whatever means.
Yeah.
So the hard end of no contact at all is you let go or you go into family law. Because if you can't find them and you can't communicate with them, isolation is one of the tools alienating parents use to put them in a hermetic container and keep any influence out that might change their child's views. It's like being in a cult.
Yeah.
I think it's important to, sorry, Joanne, to add to that, Stan, is that one of the things that we're doing through this pathway is also supporting parents where no contact becomes the outcome. And so how do we get them to continue on with life? How do we get them to prepare for, because every parent that we're meeting, the common theme is the theme of hope, and hoping that one day the narrative will change. So one of the things we do through this program is also preparing them even after the decision and working with them so they can start to build their own strength, their courage, and to continue to work forward towards the life in general for themselves, and then the possibility of, if they were to reconnect in the future, what that would look like. So it's important to understand that we are very well aware of these outcomes and what this may look like. The focus is around preparation, education, knowledge, empowering the parent to be able to give their best foot and be able to give their best chance going forward in order to know that they've done everything possible. So that's important to highlight, Stan, I think.
Yeah. Jeannie, I know you were working on a strategy for alienated children to try and find their parents again. I don't know if that's something.
No, we still do that. So that's a separate thing, but we work with a team where we see children that are relocated and they've just disappeared, and we've just been successful with a matter that we were working on for 4 years, where a family was on an annual holiday overseas, and the mother didn't turn up at the airport. So we were successful in the navigation of locating the parents. So we've got a team of, they're actually ex-federal police that work in helping to navigate those kinds of matters, which we are, as you can appreciate with this process, we have sort of a broader sense of where this takes us. So this is why when Stan said earlier, each matter, and we need to identify what that is, and then how do we start to go forward in navigating the support strategies and the people that we have on board our teams to help us. So our focus is always working in the cracks and trying to go places. We're taking those risks in order to work on, have we exhausted every option possible? But it is important to note that the awareness of the probability of outcome for some parents is no contact. And so how do we prepare them and the mindset of into the future? So that way then I think the cliche of keeping contact, keeping that front light on is continuous, because we hear of those stories where children enter into their adult years and then suddenly are seeking their parents. And we want to keep the most positive side of our parents moving forward with that hope. So that's also important. Also to note too, Joanne, that in the early days of our time with parents to work out whether, because as you can appreciate, our sort of boundaries that we're working within is also complex matters. But there are times where mediation does commence and a mediator does note that alienation could be a probability within that case that's come forward. And so not to put at risk the impartiality of the mediator, the referrals, when they come through, we sometimes have an opportunity to engage with both parents. And this is where the PTA co-parenting clinic starts to kick in, because it's like the lighter version of, it's the soft approach of us being able to really find out what is happening with that parent that's refusing contact with the other parent for the children. And so we can explore and filter through whether that parent is definitely on the pathway of wanting to disconnect the other parent from the child's life, or is it that they didn't know it was alienation or didn't mean to, and there might be some lighter issues, outstanding issues that we might be able to approach in a different pathway without the indirect concern of the worst outcome is we're now going to be spending lots of money going into court. So we've had that pathway as well, which has worked successfully. But if we start to see suddenly a parent not returning back to mediation, a parent even declining our early services, we have a very good idea that we're now dealing with the introduction, if not already active, PA. And this is where we don't want to, as Stan said earlier, speed in this process is important. So the earlier we start to work into our assessment through this program allows us then to start to engage and prep that parent and really start to form good habits, as opposed to habits that they start to gain from taking too long to get themselves started in preparation for their particular matter. So that's also important to highlight.
Yeah, no, absolutely.
Yeah.
And look, there's a question about perpetrators who are generally perpetrators of family violence and sexual abuse using alienation. And someone's just asked that, and I was going to ask it as well. So in that initial triage, is that where you're trying to?
Yeah, this is. I'll just quickly. I've put a citation in the chat to you, Joanne, if you want to share that with everyone.
Yeah.
About a case involving. Actually, it's an alienation case alienation is not mentioned in the reasons for judgment, but if I was brought in to give evidence, it's an alienation case, and we ran the remediation methodology I was talking about, so it was an alienation case. Okay, so that's the precedent we refer back to, Joanne, for those who want to know about it. Okay. Allegations of family violence and sexual abuse by the perpetrators of that using claims of alienation.
Yeah.
So we have a diabolically complicated situation here because everything relies on narratives, that we have harmful, alienating parents alleging family violence and sexual abuse against the other parent, and they themselves and then perpetrators of family violence and sexual abuse alleging that they've been alienated. Now, again, because we rely on evidence-based models of what alienation is and isn't, we can actually tell the difference in terms of whether a claim is valid or not. Now, let's say a parent is alleging family violence and sexual abuse against the other parent. The first question is, where's the police investigation? All right. Now, if there's no police investigation, the case hasn't even met the threshold for that. Okay. That's the first point. If a perpetrator of family violence and sexual abuse is alleging alienation, same story. Where's the evidence for that? And usually the targeted parent will have narrative evidence of the family violence and the sexual abuse they or their children have endured. And again, it's the evidence-based models, which are very strong and validated in the alienation field, that tell the difference between what's a valid claim and what isn't. Okay, so one of the criteria in this evidence-based model is that the targeted parent cannot have contributed materially to their own rejection. So that puts the onus on the targeted parent to show a history of a loving relationship their child has had with them, and to refute claims that they were violent or abusive to their child. Okay. Now, a perpetrator of family violence and sexual abuse will more likely have trouble showing that consistent history of a loving relationship with the child, because if they have been sexually abusing that child, there'll be other evidence to say that relationship isn't as loving as it seems. Okay, so that's one way that we can work in that space. It is a highly contested field. The reason why people make these allegations is because the quickest way to get rid of a parent is to say that they're violent and abusive, and that's an automatic intervention order. It's that simple.
Yeah.
Joanne, I just want to go through, I think the cost is really important because of this pathway to make it, because we like to be transparent with parents as well. So part of our process when we first meet up with the parents is the PTA, we do a consultation for free. That's 30 minutes where they'll book through usually the PTA website. And here we get to hear just their story and find out a bit more about what direction we need to go. Is there an opportunity to go through the PTA co-parenting clinic, or are we dealing directly with concerns of PA, and does that need to move fairly quickly? We then go into, I keep losing my mouse, and then the initial consultation. So we do what we call a joint intake assessment. So this is even before they've qualified through to the next stage. We charge the $440, and both Stan and I are present for this 60 minutes, hearing their story again, but now we're having some questions around what they've also shared with us and shared within the first part of the consultation in order for us to be able to explore and go to the next stage. With that in mind, we will brief together, Stan and I. We will then start to put a plan of who we need, and then a proposal gets sent out. And then for the complex case management services, where the parent will be looking at 2,800 for the duration of the matter. So what this means, it will include 4 consultations during the process of their duration of their matter. Any additional consultations is at the typical fee for 40. There'll be inclusive, of course, will be the briefing between referrals. So there'll be a lot of back-end work that we won't be, the parents will not be involved in, but they will be finding that the connections through the referrals, it'll come through their case plan definition. The case monitoring and coordination is incredibly important, because part of the key pathway for this is where normally other professionals will not be on a consistent phone call with their clients. We're able to have them refer back to us to be able to update us. And this is where we're able to really holistically work with the parents and just compress the time so that we can start to talk to them about what needs to happen and if there's a change of direction with their matter. Of course, all the additional referral services that we are referring all parents to, those referrals are direct cost from the referral pathway to them. So that makes it quite easy. We really wanted to make this achievable and something that was at the best as affordable as we could make it for them in order to take on that particular pathway there. Our future work, we're very mindful of the support for parents in parental alienation, child relocation, child abduction, as Joanne put earlier. By the end of this year, there'll be a charity that we want to put together called Child Reconnect. So that's something that's very important, just to help support parents where we can, where they cannot, and they need that extra additional support. So that'll be coming up in the next few months. How parents can book. So parents can book directly through the PTA website, and which is the parentingtogetherapart.com.au. Or if they have professionals involved, especially with lawyers or anyone that's involved, we can get a referral directly to us. If you need, we have a standard template referral. If you're wanting to know what that is, we can just send that out to you from our office. And that way, then that can be the referral that you send to us, and we'll know that it's you in reference to this particular pathway. And then that allows us to be able to have a good understanding of what's being sent to us, any questions we need to ask, and we can go forward from there. So that's pretty much where we're at there. Questions, I think we've answered. And look, for us here, it's providing hope for parents, and if not for their children, for themselves. And I think that's the focus that we are really intending to work with. It's such a big gap. I think for Stan and I, these are the things that we've commonly found through many of our parents that are coming directly through our pathway, is that the common denominator between both our services is we found parents need help. They need help. They need support. They need something that's going to be cost efficient, but also a pathway that allows them to be able to prepare well and give them the best chance possible. So that's pretty much, I think, from our end. I'm hoping this will give, and we're open to questions afterwards, of course, as well, later, another time. But yeah.
No, oh, look, thank you so much, Jeannie and Stan. It's been really helpful. I can see the amount of work and thinking, and I know that you've been working together to plug the gaps for parents that are targeted. So it's really valuable, and also the practical tips for those at the front of the system, hopefully trying to prevent the start of this turning into the worst of it.
Yeah, and I think the key is it's the collaboration of professionals. We need to start coming together to really look at our clients when they're parents that are coming to us, to say, what can we do for them better? What is out there? And what is this collaboration? The strength is in the numbers. And the more that we're able to be open to that pathway, Stan and I have I think you would agree, Stan, we're just about action, trying to create, we're in a position to be able to create these kinds of projects, and together if we're supporting other professionals, and of course that's coming across to us as well, I think we could look hopeful into the long term of some changes that at the moment seems very unhopeful, but if I think together we might be able to shift that.
Well, that's going to take some lobbying to do that.
Absolutely.
I just want to close by saying that women exposed to family violence and sexual abuse consistently complain about how, in an attempt to get their situation remediated, it seems that things fall between stools. It's the lack of integration between services, the left arm not talking to the right arm. We're trying to address that in parental alienation because it's been so obvious that the lack of integration affects the outcomes of these cases.
Yeah.
So that's what we're trying to address in essence. Yep.
Yeah. When you look back, you can see that there were opportunities that were missed.
That's right.
Yeah.
Yeah.
No,
Yeah.
I think that's a really good note to end on. So a call out to anyone who's a professional, collaborate, look at who else is working alongside, where you can send clients when your services aren't able to work or when they can't work now. With Family Dispute Resolution, we've already got that relationship with Jeannie where sometimes we're blocked in the FDR, we send them to her and then people come back. It's a system rather than a one-way street. And lots of exit ramps.
That's right.
So thank you.